We are back here tonight, and I'm joined by former District Attorney Michael Arcuri, here to discuss the Word of Life case. This case is really a huge landmark case for Oneida County. It involves 8 defendants, and I think the first thing that I think a lot of people think of when they're discussing this case is taxpayer money, and I want to talk a little bit about that in just a moment. But first, let's talk about the defendants themselves. So far, we know again that there are 8, and 7 have rejected the plea deals that were offered to them, and 1 has accepted the plea deal. Now, in this case, we still don't know who's going to be tried together and who's going to be tried separately. We know that at least one, Bruce, is going to be tried separately. So as a district attorney, I suppose, how do you make that determination?
Well, it isn't really you that make the determination as the prosecutor, it's really the judge. The ultimate consideration for the judge is trying the defendants together, more than one defendant together, in any way going to prejudice one of the defendants. So that's the ultimate decision.
So then let me ask you it this way then. Which does or would a DA prefer, together or separate?
Well, generally, there's no definite answer, but generally a district attorney would prefer to try them together. One, for judicial convenience, it's easier, it's less time, less hours. Also, you want your jury to see everything together. You want them to get all the facts. Now, generally, a defense attorney wants to separate the cases. Again, not always, but usually they want to separate it because they have a better ability to just talk about their client when it's just one case.
We mentioned the taxpayer aspect of all of this. This is going to be very costly for the county. Is that something that the DA takes into consideration? Not
on a case like this. I mean, obviously, generally the district attorney is always concerned with their budget, but on a case like this, I mean, it's so high profile, it's so important. He is going to do what needs to be done and what he thinks is the correct thing to do. So, the taxpayers may pay a lot for it, but certainly the district attorney's job is to do the right thing.
What are some of the biggest challenges with this case? Because we have some that are charged with murder, some that are charged with manslaughter, some that are charged with both. We have kidnapping, we have gang assault. What is the biggest challenge with this?
I mean, there's so many challenges. It's hard to even begin. First off, just trying 7 people at the same time is extraordinarily difficult. You have so many different people doing different things. You have 7 different defense attorneys all asking questions, taking different approaches, and you as a prosecutor have to make sure that what you're doing with one defendant doesn't in some way prejudice or cause a mistrial for another defendant. So that's difficult. You have all kinds of questions as to whether or not it gets separated, and the judge has to decide that. Who gets a separate trial? Should there be a separate trial? And then there's always the question of, will you be able to get an untainted jury pool, which in a high-profile case like this, you guys are doing your job, you're doing a good job, you're reporting it, but that, on the other hand, affects a jury and the ability to get an unbiased jury.
We mentioned that Bruce Leonard has to be tried by himself, separately. What are some of the reasons for that?
Well, and I don't know specifically, but generally reasons that a trial would be separated. So for instance, if let's say, for instance, you and I were co-defendants and I made an oral statement, an admission, and I said, the 2 of us committed a robbery together. Well, that could come in against me to the person I said it, even though it's hearsay, because it's an exception to the hearsay rule. It's a declaration against penal interest. However, if you and I are tried together and I said you and I committed the crime, well, that's a hearsay statement against you that your attorney is going to object to. So now all of a sudden we create this conflict where if the prosecutor wants to use it against me, great, but it's going to conflict you. So you either have to have 2 juries, which they do sometimes, 2 separate juries, or 2 separate trials. Now think about that multiplied by 7. When you have 7 defendants.
Logistically alone, I can't imagine.
Right, and that's just one of the many, that's one of the easier ones, but there are many of those kind of situations that come up. And, also, it's really easy. If you and I commit a crime together, and every single act that we do is exactly the same, easy. You try us together, we've done everything the same. Now, what if you have done half of the things and I've done twice as many things as you? Is it prejudice you to be tried with me when I've done everything and you haven't? So those are the kind of issues that come up.
Okay, let's talk about the jury pool and a tainted jury pool. I mean, it seems like everyone knows about this case. It's been in the media, and not just here. I mean, nationally as well. So, I mean, is it a good thing or a bad thing? How much do you want the jury to know, a possible jury to know?
One of the things, I mean, you don't mind as a prosecutor that people know about the case. The real question is, and the question that a judge will normally ask is, have you formulated an opinion based upon what you have heard? Okay, and that's the real question. So it's okay if the jurors hear about it. The question is, will they be able to keep an open mind, and have they not formulated an opinion based upon what they've read and saw in the media?
And then real quickly, while Oneida County is working on this case, what happens to all the other cases? I mean, it's just, there's such a workload in just this case alone, or all 8 of these cases.
Well, District Attorney McNamara has a great staff, has a staff that's certainly well capable of handling all these cases, so they'll be able to do it. But clearly, this will be, a real focus. I mean, it's going to take quite a bit of time, but there's no question.
How long would this take, do you think?
It all depends. The scope of the motions could go on for quite a while. I mean, generally, the trials in Oneida County happen in criminal trials in under a year. This one, will probably be under a year, but there's going to be a lot of work that goes into this.
Former District Attorney Michael Arcuri joining us here to discuss the Word of Life case.